Now, with the Vice President, Secretary Becerra, and Deputy Attorney General Monaco, I want to talk about an executive order I'm signing to protect reproductive rights of women in the aftermath of the Supreme Court's terrible, extreme, and I think so totally wrong-headed decision to overturn Roe v. Wade. In both formalized actions I announced right after the decision, as well as adding new measures today. Let's be clear about something from the very start. This was not a decision driven by the Constitution. Let me say it again. This was not a decision driven by the Constitution. And despite what those justices in the majority said, this was not a decision driven by history. You've all probably had a chance to read the decisions and the dissent. The majority rattles off laws from the 19th century to support the idea that Roe was a historic anomaly because states outlawed abortion in the 1880s, toward the end. But that's just wrong. The truth is, today's Supreme Court majority that is playing fast and loose with the facts. Even 150 years ago, the common law and many state laws did not criminalize abortion early in pregnancy, which is very similar to the viability line drawn by Roe. But the Dobbs majority ignores that fact. And the Dobbs majority ignores that many laws are enacted to protect women at the time when they were dying from unsafe abortions. This is the horrific reality that Roe sought to end. The practice of medicine should not, emphasize, should not be frozen in the 19th century. So what happened? The dissenting opinion says as clear as you can possibly say it. And here's the quote. Neither law nor facts nor attitudes have provided any new reason to reach a different result than Roe and Casey did. And has changed, and all that's changed is this court, end of quote. All that's changed is this court. That wasn't about the Constitution or the law. It was about a deep, long-seating antipathy toward Roe and the broader right to privacy. As the justice wrote in their dissent, and I quote, "The majority has overruled Roe and Casey for one and only one reason, because it has always despised them, and now it has the votes to discard them," end of quote. So what we're witnessing wasn't a constitutional judgment. It was an exercise in raw political power. On the day the Dobbs decision came down, I immediately announced what I would do, but I also made it clear, based on the reasoning of the court, there is no constitutional right to choose. The only way to fulfill and restore that right for women in this country is by voting, by exercising the power at the ballot box.